The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Morning, Mr. Benez.
I'd like to ask the attorneys in the second case to please turn off your cameras and mute your microphones for now.
Mr. Benez here.
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. Good morning, and may it please the court. My name is Brad Banas, and I represent the petitioner, Victor Jimenez Rodriguez. This court should join the 11th Circuit and the 7th Circuit and hold that IJs have jurisdiction to consider waivers under 8 U.S.C. 1182 D3 for U status applicants, because the board and the immigration judge made a legal error by determining they did not have jurisdiction to do this. This court should vacate their decisions and grant this petition. This case presents one straightforward legal question of the interpretation of the plain language of a statute, Your Honors. That is, whether Congress gave the Attorney General and his delegates, the immigration judges, authority to hear waivers under 1182 D3 for U status applicants. This court need go no further than the plain language.
I'm sorry, can I ask you a question? It seemed that there were sort of two questions floating around this case. One is whether Congress gave the Attorney General the authority to grant these waivers, and then the other was, and this is what Khan holds, that even if the Attorney General has the authority, it hasn't been delegated to the individual immigration judges. So which question do you think is really in front of us? Where do we start with this?
Yes, Your Honor. I think LDG v. Holder addresses that issue very clearly. And I think the question is whether what Congress did, because the agency, neither through an administrative tribunal nor a regulation, can put a limit on the authority that Congress gave immigration judges. But to that point, Your Honor, the statute says it goes to the Attorney General, and the regulation at 8 CFR 1003.10 indicates that immigration judges shall exercise the power and duties delegated to them by the Act and by the Attorney General through regulation. I believe matter of Khan attempts to use that "and" as a limiting principle rather than recognizing it as an additional principle that immigration judges have authority to do what the Act tells them they can do, as well as additional things that the Attorney General allows them to do through regulation. There are likely circumstances.
But I thought your statutory argument was that the Act gives the Attorney General the authority. You think the Act, by plain terms, actually confers authority on individual immigration judges somewhere? And where would I find that?
Your Honor, I think it gives it to the Attorney General, and the Attorney General gives it to the immigration judges as his delegates.
Well, where does the Attorney General give it to the immigration judges?
In that regulation, Your Honor, at 8 U.S. or CFR 1003.10A, where it says the immigration judges shall act as Attorney General's delegates, and then in the provision I just quoted just below that in B, that says the immigration judges shall exercise the power, not discretionary, shall exercise the power and duties delegated to them by the Act, and then also by the regulations.
And I'm sorry, I've taken too much of your time. Which of those two things are you? It sounded at the beginning that you were saying the power to grant these waivers had been delegated by Congress to IJs. So you were relying on the Act word in that sentence. But then when I asked you what was going on, or asked you to explain, it sounded like you were saying, no, the Attorney General delegated his or her power to the IJs under subsection A.
Your Honor, I think you're exactly right, that the statute gives the Attorney General power. Okay. And the Attorney General has in turn delegated that power without limitation to the immigration judges. And Your Honor, I do not believe the government disputes that immigration judges have authority to hear waiver applications under D3. What their dispute is they do not have authority to hear waiver applications under D3 for one subset of, quote, aliens, and that is U status applicants. They admit that under certain regulations, the immigration judges have jurisdiction to hear D3 waivers. They just say they can't hear it for U status applicants. Their primary arguments are twofold. One, that the existence of a separate waiver exclusively for U status applicants somehow expressly or implicitly repeals that grant of authority that's unlimited under D3. And again, I would point this court to the excellent analysis in LDG v. Holder. That's the First Circuit Court to address this decision, Your Honor. And I think it did the best job, frankly, that it said, these two waivers can be read together to work together, and that's what the court's job is to do, is to find a way to revoke.
So if we accept your argument that the plain language of this D3A does permit the Attorney General to grant waivers of inadmissibility, and in turn that is delegated by HCFR 1003, then what type of jurisdiction are we talking about here that exists in tandem with the USCIS, which also I don't think you dispute in any way that they too have this authority. So you have two different entities that have it, and one acts, is the other, is it sort of like a state federal sort of jurisdiction thing, or what is it? I mean, if one acts, does it preclude the other? And where would we determine that from? Other than I know that we have a couple of sister circuits that have pretty much given us their thoughts on it.
Yes, Your Honor. I do think that D3 provides concurrent jurisdiction. And this is something we see throughout the Immigration and Nationality Act. Something that this court sees on a regular basis is that both USCIS as well as the Immigration Court have the ability to grant a different benefit called adjustment of status.
So when that happens, is that a result that effectively there's two bites to this apple that exists? I mean, if you don't get it from one, you can go to another?
In this particular circumstance, I don't think that's an accurate representation. But for example, in the adjustment of status context, it absolutely is. You get denied adjustment of status by USCIS, you then renew the application in front of the immigration judge.
Yeah, I wasn't trying to read it so much in this particular one. I'm just trying to understand, if we hold this, what does it mean? It may not be in this particular one, but it certainly will follow from it. And I mean, that exists in other areas too. I mean, you have a state federal jurisdiction that's concurrent, and you can go to one or the other. But in this instance, your client has not gotten the answer he wants from the USCIS, but he wants now the IJ to exercise authority. Now, is the issue in this case fairly narrow? Because as I see it, it's not a question of what the IJ will do. It is a holding that was essentially that he didn't have the authority. And so all we need to do is determine, does he have the authority? What happens from there is whatever happens on remand. Is that right?
That's correct, Your Honor. That's absolutely correct.
And so this question is fairly, I wouldn't say simple, but certainly straightforward. It is simply a determination, does it have the authority? If it doesn't have the authority, then that's the end of it. If it does, then we just say, okay, you got the authority, you can do it. But he's not, you said something about mandatory, but he's not required to rule even to do it, is he? Because it's a delegated authority, but he doesn't have to do it. I would think he could consider it's already been done or those things, but that may be for another day to decide. But I'm just thinking out in terms of what does it mean to simply say he has the authority.
Your Honor, I do think that a IJ under the regulations has a duty to decide the applications before him. And in this situation, they said, we don't have jurisdiction to do it, so we're not even going to consider it. And so if this court finds that the agency, EOR, has the ability and has the jurisdiction to consider these waivers, then I think it would go back to the immigration judge. And in this particular situation, Your Honor, these particular facts where my client has applied to CIS, and then applied for an appeal of that. And again, very narrow issue, Your Honor. The decision on appeal said he was eligible for the actual U status, but not eligible for the waiver. And so all he would be doing is applying for a waiver in front of the immigration judge. And if in this situation, I don't think there would be.
Say that again. He's eligible for the status, but not the waiver because of the inadmissibility.
Your Honor, U status is a complicated thing. This court just wrote a very excellent decision last week, a 35-page decision explaining kind of the administrative and the eligibility criteria. But essentially, it comes down to this: if you're a U status applicant like my client who was brought here as a child and illegally entered the country, you have to apply for U status as well as a waiver of inadmissibility at the same time. And under the U status regulations, the agency, CIS, cannot grant U status unless they also grant the waiver. So they do the decisions at the same time. So you have essentially a joint decision. And so if you get accorded U status, that means they've granted both the waiver as well as the status. But you can have a decision like we had here where they say, yep, you're a victim of a qualifying crime, you helped the police, you meet all of these eligibility criteria, but we're not going to grant the waiver. And because we're not granting the waiver, we're denying U status. And so it's only in those situations where renewing a waiver in front of the immigration judge would actually remedy, right, the issues for these folks. If he got denied on U visa eligibility criteria, he can't renew that in front of the immigration judge. We're not arguing that. It's just this narrow issue of a waiver. And we're not even suggesting that the immigration judge can do a D14 waiver. He's more limited to the D3 waiver, which is less expansive. I'm sorry, Judge Harris.
Yeah, I'm sorry. I want to sort of follow up on what Judge Nguyen was asking and make sure I understand your position. If we were to hold that the immigration judge has authority to consider this authority has been delegated by the AG to the immigration judges in removal proceedings. In your view, would it be okay if this was sent back to the IJ and the IJ said, I'm not granting your application, the people over at CIS denied it?
Yes, I think that would be okay. As long as he recognizes the authority that he has the ability and jurisdiction to consider it, he can make whatever decision he wants or she wants.
Basically, it'll be okay for you to then make an appeal back to us saying that he erred in doing so, if that's all he does. That's what you would say.
Well, Your Honor, a waiver is discretionary, and discretionary relief doesn't make it to this court, frankly. But I will note that I can see a role for prudential exhaustion doctrines to develop. The government, their second big argument is this is just impractical, right? They paint the scenario where people in removal proceedings who don't have U status applications pending are just going to come in and ask for a waiver. And in such a situation, I can see an immigration judge saying, hey, I have jurisdiction over this waiver, but you haven't even applied for the separate status. You haven't given CIS an opportunity. And so I'm not going to hear it. I'm going to deny it and choose not to hear it under, again, in federal courts, we call it prudential exhaustion. And I'm not sure we call it immigration court.
Yeah, I'm more worried about the situation was it Meritor, the one of the cases you're relying on in the 11th Circuit,
yes, Your Honor.
where, like, they kind of fought about it. Like the IJ wanted to grant it, CIS didn't want to grant it. It was sort of a race to see who could get an opinion out first, and then a lot of collateral litigation about which one was controlling. And I think that's sort of the concern I think that's front and center about this idea that you would have two competing determinations and then a lot of litigation trying to figure out which one of those would control.
Counsel, Judge Harris mentioned, and aptly so, the two tiers, if you will. Seeing that we went along the discussion as to the IJ, but would you agree that if the Attorney General doesn't have the power to do this, then clearly the IJ couldn't, right? It's derivative, right?
I'm sorry, Your Honor.
Immigration judge.
I'm sorry.
Can you hear me? Mike?
I can now, Your Honor. I'm sorry.
Mike, can you hear me? That the IJ can only do this if the Attorney General could grant this, correct?
Yes, Your Honor. And I don't think the government disputes that.
Say what now? Say it again.
I don't think the government disputes that IJs have the authority to grant D3 waivers. They do in other circumstances. They just say it doesn't extend to U status applicants.
Okay. What about the terms of the idea that the Attorney General can only do it for people outside the United States? The Third Circuit.
Your Honor, my answer is twofold to that. First, the actual language of the statute, the plain language, says it's for people seeking admission. And admission is a legal term of art in immigration law. People regularly inside the United States seek admission to the United States as a legal matter. And that'd be my first point. The second point is if you look at the subsection just above, so this is technically 1182 D3A II. If you look at D3A I, it identifies a separate provision and separate authority for a consular officer. That is someone outside of the United States. And so they've taken into account people seeking admission from outside the United States in a different provision. But they've separated it out, and so the Attorney General can do this too. And so this idea that this is limited, as they identify in the Third Circuit and Sunday, to folks seeking admission, I think it's a narrow view of the term admission in immigration law, that admission can only be from outside the United States. I think that people seek admission from inside the United States all the time, just through different legal mechanisms, such as a U status applicant. Just to put, again, back to the visa, they get a U visa. After 3 years as a U visa holder, they can then apply for adjustment of status. To qualify for adjustment of status, you have to have been admitted in lawful presence. And so the U status is seeking admission to the United States. And again, I think Sunday, the case out of the Third Circuit, really unnecessarily narrows the definition of admission and kind of misreads it in the immigration context.
The Third Circuit just got that wrong. That's your answer.
With all due respect to the Third Circuit, Your Honor, that's my answer.
All right. I think Judge Harris has a question.
Sorry, because I know you're running out of time, and I want to go back to the regulation because, as I understand your argument, and this is how I understood it from the brief too. You're with the Seventh Circuit and the 11th Circuit on this. That the necessary delegation here comes from 1003 subsection A. And I just want you to respond to the concern I have about this, that when I look at this regulation at a whole, the first one, A, subsection A, sort of describes what an immigration judge is. The title is appointment, and it just says this is what immigration judges are. They're the attorney general's delegates in cases. But it's subsection B that talks specifically about what are the powers and duties of the IJ. And in that one, it seems to say you need what they can do in these hearings as the AG's delegates is what has been delegated to them through a regulation. And so I'm having trouble reading the regulation as a whole to mean that sort of B is superfluous. Everything has already been delegated.
Your Honor, I think our argument is that first, let's say the second clause of the first sentence says that the IJs shall do the powers of the act, as well as things that are done by the regulation.
But you already told me, I thought before, that there's nothing in the act that delegates to the IJs the authority to do this. That what the act does is give that authority to the attorney general. And then as I read B, it sounds like what you need now is some regulation that delegates the attorney general's authority to grant these waivers in this context to IJs.
And Your Honor, if I may answer it in 2 points, and then I'll sit down and let my opponent come up. I think our argument is this is a general delegation of all of the authorities of the attorney general. That's the first point. The second point is, again, the government doesn't dispute that IJs have been delegated the authority to hear D3A waivers. They do that. They don't dispute that. They say that delegation of authority doesn't include U status applicants. And I do not think they can both say it delegates authority to the immigration judges to hear D3A waivers, and that delegation has no limitation to U status applicants in the statute or the regulation, and go from there. And so I guess that's our answer, Your Honor, on the regulations. Thank you so much.
Thank you. Mr. Tennyson? Mr. Tennyson? Mike, is Mr. Tennyson still on the line?
He does not appear to be, sir. I think he disconnected. I'm hoping he'll come right back. I'll give him a call, sir.
Thank you.
Aha. Okay, great. Go ahead, check it. Hi, can you hear me?
We can hear you, Mr. Tennyson. At what point did you drop off?
I reached over to unmute myself and somehow managed to disconnect.
So you heard all of the,
I heard all of, yes, of opposing counsel's argument. We're in
make sure
good
you
shape.
That's right, very well.
Okay, yes, I'm in excellent shape there. Okay, great. Let me start by, I guess I'll apply, Robert, may it please the court. Robert Tennyson for the government. Briefly, let me apologize for dropping. Also, I sent a 28J letter yesterday. I apologize for that being late. And when I referenced, I guess what, the site in Mendoza, in Mesa Mendoza, I had referenced the earlier Mesa Mendoza case out of the Seventh Circuit, not the more recent one, which is at 973 F3rd 656. The point is the same, that immigration judges, that a grant of a waiver, of a D3 waiver, does not result or does not, forestall the removal of a non-citizen in proceedings. So it doesn't matter. I mean, it does matter which one I cited, but the end point is the same. Let me get to the particulars of the argument. I think there are two things there's one thing I want to focus on, and that is the problem of attenuation here. First, under 1229A, immigration judges, 1229AA.
Before you go there, you made a point, I think you were speaking to D3A guarding the Attorney General, saying the Attorney General may not grant waivers of admissibilities to non-citizens already present in the United States. Is that the point you were making earlier?
The point I was making earlier out of Mesa Mendoza
let me ask the question. I know it's in your brief. Is that a point you're standing by today, I should say?
That the immigration judge cannot grant a D3 waiver for somebody who's already been admitted into the United States? Yes, because because the waiver language itself requires someone who is seeking admission into the United States.
So give me your answer to the 8 U.S.C. 1225A1, which states an alien present in the United States who's not been admitted shall be deemed an applicant for admission. And square that also with the DHS's own regulation, which is at 8 CFR 212.17, which states that U visa applicants may seek a D3A waiver?
Right.
Do we just ignore that? I
Here.
guess what I want to ask before you go, do we just ignore those things, or I mean, give me the straight up answer first before we start nuancing, because it'll get lost on me.
Okay, the straight up answer is if you've already been admitted to the United States, and I believe that was the case in both Mirador and Mann, the individual had already been admitted to the United States in some status, then the D3 waiver isn't applicable to you. Actually, the case here is not like Mann or Mirador. The petitioner in this case is in fact someone who entered the United States unlawfully and is therefore, and is inadmissible. So the question is, and USCIS has and does grant waivers of inadmissibility to individuals who are inadmissible in the United States. So that's not, I don't think we're going to stick, that's not an argument insofar as it has to do with individuals who are inadmissible that is necessarily the case. It is one so that's the division. That's the dividing line between someone who's been previously admitted or someone who hasn't. So the petitioner here hasn't been previously admitted. That's not going to forestall a waiver. What does forestall a waiver what does give the board the ability to construe the availability of the waiver has to do with two things. First, that language about admission into the United States, someone seeking admission, who then has documents or who has a waiver of the documents under the language of D3A2. It's broad enough that there's a question about whether or not, how far in advance or after, whether or not it is attenuated in time. The waiver is attenuated in time from the grant of admission through the grant of the U visa. Yes,
can I say, I just want to, I understand your argument. This all goes to the point, if I'm understanding right, that the Attorney General doesn't have this authority under the statute, right, to grant waivers in this particular circumstance you're talking about?
That in this particular circumstance, the Attorney General doesn't have the authority,
okay.
Right.
So my question is, whoa, let me stop you there. My question is why that's properly before us. Khan didn't say that the AG doesn't have the authority. Khan said, we'll assume the AG has the authority. It hasn't been delegated to the IJ. In the case before us, all the BIA said is we're following Khan. The IJ hasn't been delegated this authority. So how is this ground, which the agency didn't rely on, available to us as a reason for denying this petition? I don't understand why we're talking about this at all.
Right. Your Honor, I think that this is in response to the petitioner's argument. The petitioner's argument is full bore that the statute requires immigration judges to do this. Our response is to that, you're right. If that is the case, then it's not an argument that petitioners, insofar as
I'm confused on that answer. I don't know quite how you answer that right there. The question is simple. Even if the AG has such authority, the question is, do you not agree that if the AG has the authority, then the IJ has the authority? Because that's what seems like you've been arguing the whole time, but I don't know where you're going with this now. Is that true?
Okay.
If the AG has the authority, then the IJ has it. Is that correct?
That is not correct, because the AG can have the authority to grant that outside of the context of removal proceedings. Say, for example, under the regulation, it is possible for an individual who has been from abroad or even at the border denied the D3 waiver not to go into immigration proceedings to contest it, but within 15 days to go to the board and contest it outside the context of removal proceedings. Just because the the Attorney General has the authority to grant that waiver in some context does not mean it has the authority to grant that waiver in the context of a removal proceeding. The sole purpose of a removal proceeding is to determine inadmissibility or deportability, and whether that is forestalled by either relief or protection that immediately ends the removal proceedings. If an immigration judge grants the D3 waiver, that doesn't end removal proceedings. The immigration judge can then just go on and order the individual removed. And then we wait. And what we wait for is USCIS to actually adjudicate the U visa. There are two attenuation grounds. Yes, Your Honor.
Before you get to attenuation, I just want to make sure I'm understanding where we are in this argument. So your colleague says, what are you talking about? Of course, IJs are authorized to grant these waivers, and we know it, and the government wouldn't contest that they're allowed to grant D3 waivers. And so your response to that, as I understand it, is what the BIA said in Khan, basically, which is no, they're authorized to grant them only outside the context of removal proceedings, this particular thing on review from the district director at the entry point. But that's the only context in which they can grant it. They're not authorized. There's no regulation authorizing IJs to exercise whatever power the AG might have in the context of a removal proceeding. That's your response to what your colleague has been saying?
That is correct, Your Honor.
Okay.
That is correct.
On that point, are you arguing that however we might read these regulations, we would defer to the BIA's reading of the degree to which IJs have been authorized to do this?
Yes, Your Honor. That this is a Chevron step 2 question in that regard. Yes.
Wouldn't it be an hour question?
It would be an hour question under the regs, or a Kaiser question. Yes, Your Honor.
All right. Sorry, this is my last question. I did not, to the extent this delegation question turns on this regulation, this kind of housekeeping regulation at 100310, I didn't see the BIA really construing that regulation or analyzing that regulation. So our reading on this one would be de novo, right?
I would say that the board is, okay, I suppose so. The board is, insofar as it's looking at identifying 1003.10B as the source of delegation authority, I think that it does that because it's identifying which provision has to do with delegation. I don't think that every time the board identifies a particular provision and says this one's relevant and we're talking, these are the relevant provisions, we're talking about these, that the implicit, these aren't relevant, somehow is something that's not considered. This court can actually consider it. So the board doesn't have to go through, and unless there's some reg that necessarily talks about this, there's no reason for us to be looking at other regs in the vicinity. But if this court thinks that it should have looked at 1003.10A in addition to 1003.10B, then it needs to go back to the board to identify, to look at both regulations and construe them together, rather than just saying the board's construction is unreasonable, if that makes sense.
It does, but can you show me where the board construed any part of this regulation?
I mean, what it was construing, it didn't construe any part of 1003.10A, right? It's construing 1003.
Or B. It didn't construe 10B. I mean, it just cites point 10 altogether at the end of a series of quotes, but it's not like the BIA says, let's look at the language, here's how we read it. I mean, I just don't see what we would defer to.
Right. I think the board sort of, and maybe it's because the board has historically taken that language to mean, and has historically construed the statute, the regulations to sort of generally require or generally not to infer a delegation in the absence of a specific delegation. Does that make sense? So unless the regulation specifically delegate something, the board has historically taken that and has generally considered that to just be a given point. So it'll cite it. There's this history to it. If this court needs me to further brief that history, that's fine. But this seems to have been a background proposition that the board has held, and then cited to the particular provision for that regard, in that regard, and then said, look, there is this single exclusive delegation here, right, in 1235, and that's it. And outside of that, that means that's the extent of the Attorney General's, the extent of the delegation of the Attorney General in these cases. So to answer your question, is it developed? No. Did the board think it had to develop it? Probably not. Does it stand as sort of a general, as one of its background principles and how it understands it? I believe it does.
Mr. Tennyson,
Thank you.
This case seems to be getting more and more complicated. It started with a very simple question. Can you just answer the simple question? Do you contest the fact that the IJ said it lacked the authority to grant the D3 waiver?
The IJ actually didn't address the D3 waiver. It was only the board that addressed it. And the board just said,
Do you stand behind that they lacked authority, they didn't address it? Question?
That the board said that IJs don't have the authority to grant the waiver.
That's what I mean.
Full stop in this decision, and they said it in Con as well.
I know that. That's what I'm asking. Do you stand behind that decision?
Yes, Your Honor.
Okay, all right. But then, and you do so because, just simply, why does it lack that authority? Because that would be the end of the story. If it goes back, we know there are a lot of things that may be considered, but why do they lack that authority?
Because the express delegation to hear particular to hear the waiver in particular instances where it has an impact on removal.
I don't want you, I'm talking about this instance right here. I don't want to talk about a law school exam question. I'm talking about this case under these facts. Why does it lack the authority to grant the D3 waiver as the BIA suggested it doesn't? Why? Why not?
The board in this case, right, the board in this case purely said the reason why the IJ doesn't lack the authority to grant the D3 waiver is the reasons we gave in Con. And then cited to Con, I believe it also cited to Mirador and Sunday, but it definitely cited to Con and said, as a result, there's no authority to adjudicate the D3 waiver for a U visa, and so we're not going to remand the petitioner's case back to the IJ to hear it.
Well, as Judge Harris said, there are limitations in that holding, so you got to live with that, right? So is it explained why that wasn't really reached? Well, it was just assumed. I mean, tell me why you can rely on Con for that proposition.
For that proposition?
Yeah.
That the IJ can't adjudicate the waiver? Crucially.
Solely on that reason. Why?
Why? Because that case governs the question of whether or not an IJ can grant the waiver to someone seeking a U visa. And so because that case says full stop, you can't do it, the IJ can't do it for someone seeking a collateral U visa waiver, the petitioner in this case, who is seeking to have his case remanded for an IJ to make that determination, cannot get the remand because the IJ can't grant the waiver.
So you have a lot of reliance on the matter of Con case, which or a decision by the BIA, and say we should give it some deference. But that decision, correct me if I'm wrong, never mentioned nor even discussed 8 CFR 1003.10a, did it? It didn't even mention it, did it?
No, Your Honor, it did not.
No, it didn't. And then secondly, let me ask you the other thing. Why in the world would this case that was decided in 2015 and 16 rely upon the predated version of 212 4B, which was amended 2011, but that's not the part it relied upon. If you look at the language it uses the language that was amended. Why did it do that? That's got to be error. I mean, look at it. It's the pre-2011 language to conclude that this authority exists. How in the world can we give deference to something, to a decision that paid no attention to the language that came about in 2011.
Right.
Right meaning how can they do it, or right meaning they did. They
give me a moment to think. One thing is I think that the language sort of there is the change in the regulation.
Let's agree on at least in terms of what we're talking about. It's no question that the matter of con relied upon the pre-2011 language. No question of that. It looks as reading right there, right? And but you got 2011 language that comes about, and it makes this decision in 2015 or 16, and it's got this earlier language it's relying upon. How do we even think about giving a decision like that deference? Because it's wrong.
Right. I think, and let me see which. I want to make sure I know which provision you're pointing to. It's 12.4b. Is that what you're pointing to, or which section are you?
No, 12.4b used to state before 2011 that an applications for D3A waivers shall be submitted on a form I-192. Here's the language: to the district director or the official in charge of the applicant's intended port of entry. That's the language they use. They changed that language in 2011. And yet this decision relies on this pre-2011 language.
Right.
And it's decided in 2015 or 16 or so.
Mr. Tennyson, you have to tell us.
How do we get that deference?
The board at the one.
I'm sorry, Chief. Chief, you had a question.
Saying, then you have to say, Mr. Tennyson, then you have to tell us why that change wouldn't make any difference in the analysis, right? That's the structure of an argument.
Right. It doesn't make. Right. I think the difficulty, and the board actually cited out the problem in the regulation, right? I mean, there is footnote 6 in con that has to do with the notes that those regulations, that the regulations are outdated. And make reference to the former waiver provisions in other sections of the act. But those provisions, it notes that language is out of date and says it doesn't make any difference here, essentially, in footnote 6. And so con does appear to address that question and says it makes no difference with regard to this section. Very briefly, it looks like my time's off and stuff. There's the board had this attenuation issue that it had to deal with, right? The statute has 2 attenuation problems if you apply the U visa, or if you apply for the waiver for the collateral U visa. The first is it's attenuated in terms of removal proceedings. That is, removal proceedings are about removal, inadmissibility, deportability, determining whether or not an individual is removable. Granting the D3 waiver doesn't appear to do anything with regard to that question of removability. That's 1. 2, there's the attenuation of time problem. That is that granting the waiver traditionally granting a waiver by an immigration judge doesn't mean that the U visa is going to be granted immediately. And in fact, you may have to wait for that U visa to be granted down the road. Here, that's not the case. Petitioner already applied, and it was denied. So the board had those 2 attenuation problems. 1, the attenuation from removal proceedings. 2, the attenuation in time problem. Con is a response to that. And the response is IJs can't grant these in removal proceedings because it's so far abroad. And and we're looking at, and here's the circumstance when we can grant it because it isn't attenuated. And also there are all these administrative problems that result if we do grant the waiver because it's attenuated in time. If the court has no further questions, the government rests. Thank you.
Thank you, Mr. Tennyson.
Thank you, Your Honors. Just 2 quick points. 1, I think we need to look and see exactly how Kahn worked. Kahn identified an ambiguity by looking at two different statutes and determining that their interplay created an ambiguity for it to interpret. That's simply wrong. The plain language of the provision.
But counsel, can I ask you the same question I asked your colleague? I'm with you on Kahn. They say there's an ambiguity, there's a lack of clarity in the interplay here. But then what Kahn says is we don't have to resolve it, because even if the AG has the authority, it hasn't been delegated to the IJ. So I have the same question for you I had for my colleague. I don't see how the preliminary threshold question, does the AG have the authority, is before us. Like, it wasn't relied on by the agency in this case or in Kahn, and we could not deny the petition on that ground, grant it on that ground. It's just not in front of us because it's not what the agency relied on.
And Your Honor, I can only respond by pointing to the analysis in LDG versus Holder.
But LDG, nobody was contesting. It was taken for granted, I think, based on prior Seventh Circuit law, that if the AG had this authority, so did the IJ. So the only question they had in front of them there was, does the Attorney General have the statutory authority? I would point you to whatever the follow-up Seventh Circuit decision is, where they say exactly what I'm saying now. The AG came to court and started making all these statutory threshold arguments about the AG's authority, when we're only reviewing the BIA's decision that if the AG has the authority, it hasn't been delegated to the IJ. And we can't reach that in front of us. If they want to raise that on remand in front of the BIA, they're free to do that, but the government can't rely on that in front of us. So I just don't understand why. I mean, it's an interesting question, but I don't see what we can do with it.
Well, again, this is my reading of LDG, and I of course defer to yours, Your Honor, is they say that the statute that's relevant is plain, and that no regulation can limit the authority that Congress has given to the Attorney General and his delegates. And they cite to 1003.10a and identify the immigration judges as delegates. And this is what they say: we're not free to write in a limitation on the Attorney General's powers that Congress did not impose. Your Honor, I understand the gap you're pointing out. I really do. And it may be something best for the board to finally analyze. But I do think the decisions in Meridor and LDG, as well as its progeny, do answer the court's question, because I think it is, the statute says one thing and a regulation can't contradict the statute. I think too,
we need to look at another Seventh Circuit decision. That is the Baez-Sanchez decision.
That's the one I was trying to say.
That's the one she's saying we should look at. That talks about delegation to IJs.
And it also rejects Kahn, Your Honor. And I don't disagree with that.
Kahn is properly rejected. There's no question in my mind about that. Maybe others find differently, but Kahn is relying on this pre-2011 language inexplicably. That language was removed by a 2011 amendment, and it's got it right in there. That makes no sense to me. I don't know how you write out and say that's not consequential when it's relying on it. So I have a serious problem with giving deference to Kahn in this case. So then we then look at guidance from our sister circuits and how they've done it on, and that is a case that it was discussed there. But I think the bottom line is just a question of, did they have the authority to give it? End of the day, I don't see what the big problem is, to be honest.
and Your Honor, I think if I may just respond and add one very short point. Your Honor identified at the beginning of this argument, this comes down to one question, whether they have the authority to do this. And I think Judge Harris points out the gap that Congress gave them that authority, but we need to see the authority in the regulations to the immigration judges. I think Kahn doesn't address really that second point, and if it does, it's
well. Your
it's not
point being, if the plain language of the statute speaks to it, you can't regulate it away. That's really something we have to decide. If the Congress gives it, the agencies can't come out and do it and take it away. They seem to have the main authority here.
I think that's the lesson from LDG. And just a very quick last point. I know your time is precious. The government keeps raising this question of attenuation, and I would just say we haven't seen the parade of impracticalities in the Seventh Circuit, the 11th Circuit, that the government raises from these issues. And secondly, this idea that these, you're going to have a waiver decided before the use status application is decided. I think if you look at all of the facts and all of the cases we're discussing, that's just not presented. And I, in my initial argument, I noted that if someone tried to raise a waiver for a non-pending use status application, I think the immigration judge could say, hey, I have authority to review this application, but it's not ripe. It's not exhausted, whatever that answer is. And frankly, the wait times are just another part of the use status program that is unfortunate and broken, that it takes 57 months for USCIS to make a decision on one petition. That shouldn't come into the analysis of whether the Congress gave the Attorney General authority to do this and he delegated it to the immigration judges. Thank you, Your Honors. We would ask that you grant this petition and remand it to the immigration judge.
Thank you, counsel. We appreciate both of you for your fine arguments. I wish we could come down and greet you. And we thank a virtual shake. Thank you so much. We really appreciate it. And please know we wish you well. Stay safe and be well. Take care, counsel. Thank you so much.
Thank you very much.
All right.
They're all here, Judge.
All right. Mr. Bonner?
Yes, good morning, Your Honors. My name is Charles Bonner. I'm one of the attorneys for Mrs. Oak, the appellant. I will use 12 minutes of my time and reserve 3 minutes. This case impacts 3 important principles that we Americans cherish. Number 1, freedom. Number 2, no one is above the law. And number 3, God-given constitutional inalienable rights. So let me tell you briefly the story of how the defendants here violated Mayor Oates' rights and how the trial court became an advocate for the defendants, resolving disputed issues, including issues of credibility, in favor of the defendants, contrary to law, and creating palpable injustice to Ms. Oates. First of all, it was a July.
Let me interrupt because
yes.
Those are interesting questions and interesting things to discuss. But what we really ought to get to are the issues in this case.
Yes.
And the issues as they pertain to, first, the question of absolute immunity.
Yes.
That was granted. And even, taking the facts aside, we will interplay them with the issues. But why don't you go directly to the issues in the case before us? We have only at this time, how many defendants do we have before us now?
We have defendant Holloman, Hammond, Chapman, and Wood.
And so the trial court's dismissal of this case here relied upon what?
Well, one, as to absolute immunity, she relied on the concept that a officer testifying before the grand jury has blanket absolute immunity. Where she erred is failing to understand that there's no absolute immunity for conduct taking place before or after. That is conduct that's administrative or investigative. No one is above the law in America. There may be qualified immunity, but it's not absolute immunity. And the facts here show.
So to follow your point on that, essentially what you're saying is, yes, if the allegations rely upon testimony given at the grand jury or trial, but in grand jury, there's absolute immunity. But your point is there are allegations here that fall outside and you don't need that testimony to make that allegation. What specific ones are you speaking to that do not lie upon the grand jury testimony in this matter? What is that?
Those facts include the fact that Ms. Chapman, defendant Chapman, concealed from the district attorney, along with the other defendants, the fact that there was.
Excuse me a minute. Judge Harris, are you frozen in place? I was looking and you weren't moving, so I didn't know if you'd left us or not. I was.
Am
Chief,
I back? I can hear everything. Can you guys hear me?
Oh, okay. I just interrupted because I saw that you all of a sudden froze, and I didn't know if you left us.
All right.
Yes.
So proceed.
Right. Yes, Defendant Chapman conduct before and after the grand jury concealed from the district attorney the fact that there was an economic development committee. Defendant Chapman had evidence. She had interviewed witnesses. She had documents of the economic development committee and the plan. But she repeatedly told the district attorney Montagnier that there was no such thing as an economic development committee, and therefore all of the expenditures that had been allocated for the economic development committee were fraudulent and without any kind of receipts supporting those expenditures. She knew that was false.
Well, let's deal with you got two conspiracies, one conceal, one fabricate. It appears to me that all of the fabrication information at least comes from that grand jury testimony. What did show me an allegation that shows something outside of that grand jury testimony on fabrication?
Yes, exactly. For example, Defendant Long gave Ms. Chapman files showing the travel expenses. Now, these travel expenses were in Chapman's possession. The defendants, including Chapman, never provided those expenses to the DA and never provided to us, who were representing Mayor Oates in the criminal case. So instead, she went and testified, presumably, that there was no such expenses. But more importantly, there were two key issues here. One, the Economic Development Committee and whether those expenses, that committee existed and whether those expenditures were legitimate. And two, whether there were any receipts verifying the business purpose of those various expenditures. Chapman knew that because she had frequent meetings in LGC's office where the files were within eyesight of Edmund and Holloman and Hammond, and they knew. They were literally trying to create a case and then hide the evidence to convict an innocent person. And we know she was innocent.
So what did she fabricate?
Well, what she fabricated, that there was no Economic Development Committee. That was a fabrication. It was a lie and it was a fabrication because she had hard evidence from a witness named Andrews who gave a declaration. She had evidence from even Long, who gave her evidence of the Economic Development Committee. She had evidence from Reginald Smith, who had traveled to D.C. to meet with the Obama administration to try to bring economic development to this Princeville historic town. So rather than giving the defense, us defense attorneys who were defending Mayor Oates, that evidence, and rather than giving it to the district attorney, she hid that evidence and fabricated the idea that there was no supporting evidence and that the Economic Committee didn't exist, and therefore the DA brought the charges. Yes, Judge Hunt.
I'm sorry to interrupt. Can I just ask you a question about the record? The district court said that it was undisputed that Chapman had turned over her investigative files, which included a lot of conflicting evidence of the sort you're describing. Some people thought there was an Economic Development Committee, some people thought there wasn't. And the district court said it is undisputed that she turned over those investigative files to the prosecutor. She emailed it to one of them and the other one was CC'd or something like that. Did you in fact dispute that? Was the district court wrong about that being undisputed?
The court is absolutely wrong. And if you look in the record at 886 through 901, you'll see repeated testimony from DA Montagnier that Chapman repeatedly told her, we've given you all the documents, there's no more documents, and there's no such thing as an Economic Development Committee.
I'm sorry, those are sort of two different things. I do understand that it's alleged that after turning over those files, she said, I don't have anything else. And that's a separate point, but you don't dispute, right? They have the emails that the files were some portion of evidence suggesting that there was no Economic Development Committee was in fact turned over to the prosecutors. I agree. I understand that you just. Sorry. Go ahead.
The evidence that should have been turned over was the file that they all concealed. That was the evidence of the Economic Development Committee, along with the files of the receipts. And we knew they had the receipts because they used the receipts from the PNC bank file for Mayor Oates to craft the indictment. So we knew they had those two files. And so that's why when Judge Smith ordered that we do a site inspection, ultimately Edmund said, oh, well, there's some other files in my office. They were right in their desk within our site. She could have reached and grabbed them. Those were the two key files. Yes, Judge.
Okay, can I my only other question, what is the constitutional cause of action in this case? Is this a Fourth Amendment violation that you're alleging?
It's a Fourth Amendment violation, deprivation of freedom, and it's also a 14th Amendment violation.
Right. I have questions about the 14th Amendment, but on the Fourth Amendment, is the seizure the part where your client was ordered to surrender by Evans after she was indicted? Then she was ordered to surrender, and as I understand it, she went to the courthouse and was fingerprinted and released. Is that right? But that's the seizure.
She was arrested by Chapman. She was arrested by Chapman and had to be fingerprinted. So her liberty was restricted. Her freedom was at risk. She was facing 68 years in jail at 48 years old.
No, I understand. Let me just. So it sounds like I'm just reading from the district court's second order in this case that Evans instructed Oates through her attorney that she had to surrender at Superior Court, and there was an initial appearance in court, and she was fingerprinted. Defendant had her fingerprinted and released. But so that's the seizure, right?
That is the seizure. That's correct.
Okay.
Her liberty is impeded.
I understood. And so my question is, it sounds, at least from this, as though it was the prosecutor, Evans, who ordered that she be brought to the courthouse for an arraignment. And so I am concerned, we've held in some other cases that even if an investigative officer misleads a grand jury to get an indictment, if there's an intervening cause between that indictment and the actual seizure because the prosecutor orders someone arrested or orders someone to surrender, that kind of breaks the causal chain for purposes of your Fourth Amendment claim about the seizure. And I just wanted to make sure I understood the record and see if I was wrong to be concerned about that.
Well, you're not wrong to be concerned about it, but the conclusion has to be analyzed. Here, there was no probable cause to arrest Mrs. Oates at all. So everything that occurred thereafter was the fruit of the poison tree. And we know, even with Mr. Long, if we look at Mr. Long's testimony right up on March 27, 2013, which was just 2 days before they released this state auditor's report, he testified he had no evidence that Ms. Oates had committed any crime. Likewise, Holloman testified, and this is in the record at 231. Holloman testified he had no evidence that Mrs. Oates had committed any embezzlement. There was no evidence. All Mrs. Oates wanted to do is have an accounting for the $26 million FEMA money that no one had given any accounting for her little impoverished town. She went to LGC, the people who were in control of the finances, for help. The very second day after she complained on July 30, 2012, the very next day, they seized all the records. The temporal proximity of that action is pregnant with probative evidence itself. Why? Why were they investigating Mayor Oates instead of investigating her complaint of the missing $26 million? And then you look at the credibility in this case, both the credibility for Chapman as well as the other defendants. Chapman testified again repeatedly that she knew nothing about the Economic Development Committee. That was false. That is what misled D.A. Montagna, as she stated in deposition and in declaration. And then you look at Edmund and Holloman and Hammond. They claim that they knew nothing about this spreadsheet. Well, they used the spreadsheet from this file, the PNC bank file for Mayor Oates, to craft the indictment along with Chapman. But yet once they had to turn over this file, they claim, oh, we didn't know anything about the spreadsheet. We didn't create it. And we never saw those files with the Economic Development Committee and with the receipts, with the business purpose written on the back of the receipts. Those lies are credible tribal issues for a jury. They impact whether or not the defendants indeed deliberately and intentionally fabricated evidence, and whether defendants, out of their 20 meetings, you count up the meetings, had more than 20 meetings, whether they intentionally conspired to jail an innocent person. So once you create a crime, you hide the evidence that's in your office, in the case of Edmonds, within an arm's reach, then it's the fruit of the poison tree. You got an innocent person, everything that flows from that violates the Fourth Amendment and violates the liberties as well as the due process aspects of the 14th Amendment. And the trial judge got it wrong by saying there was no identifiable constitutional right that Chapman violated. This case is totally an injustice to Mayor Oates, and it should be reversed. In fact, plaintiff's summary judgment should be granted. But I don't want to use up my time. I want to finish now to have my save some time for rebuttal.
Thank you. Thank you, Mr. Bonner. Mr. Bergstein?
Sure. Let me use my time to fill in some blanks here. The record in this case is huge, but I think it's very revealing to take a look at Joint Appendix 888 through 907, where Montagnier testifies about various ways that she was misled by the defendants about the existence of the economic.
Let me ask you a question regarding, you have a 1983 claim. 1983 in and of itself doesn't exist in a vacuum. So your colleague has indicated there's a Fourth Amendment claim here. Is there a Brady claim being asserted?
Yes. Mr. Bonner says yes. So
well, you're not going anywhere with that because you didn't go to trial on it, and Brady claims are pretty much not allowed in that. And didn't mean to walk you into that, but I'm just trying to understand what your allegations are here. The trial judge granted absolute immunity because she says, well, these come out of the grand jury testimony. And if you look at the fabrication and go back to the allegations there, they nearly all reference the grand jury testimony. Recklessly failed to show the grand jury, for instance, in the First Amendment complaint, or testified before the grand jury. There's no question that those arise from grand jury testimony. But I want you to focus on the concealment, which we didn't get to talk about it. And the reason I bring that up is because you do have an allegation in which you said from July 2012 to the present, which seemed to indicate there's something outside the grand jury's testimony that would support the concealment charge.
Let me talk about that. Montagnier testified in deposition at length, page 888 to 907, that she had numerous meetings with the LGC representatives and Chapman as Montagnier is preparing her case, that they misled her about the existence of the Economic Development Committee. She says this repeatedly, and she relied on those representations, and they knew they were relying on her. And Montagnier's memo that she wrote when she decided to withdraw the charges is very revealing, and that's at page 2299 to 2306. And she talks about the sequence of events and how she was misled. And, for example, Edmondson and Holman told Montagnier that the Economic Development Committee didn't exist. And LGC then tries to block a subpoena to review the records in their office, which Montagnier never saw. And when Montagnier finally saw the records on the eve of the criminal trial, she said she was, quote, shocked at the volume of documents that she had never seen before that were sitting in the LGC's offices all the while. I think there were thousands of records. That's page 3750 to 3751, how shocked she was at the volume of documents that were there. Why didn't they tell her this sooner? And she said, as soon as she saw those documents, quote, there goes my case. So, and she said also that not only were there credibility issues about these belated documents, but there were, quote, severe evidentiary issues that led to her decision to abandon the case. That's page 2303. Now, in granting summary judgment, the district court at page 3738 talks about sort of alternative reasons why the defendants may not have produced these records in a timely way, but that really resolves issues of their intent. She says, well, the volume of documents in the LGC offices was overwhelming, and the office was in disarray and disorganized, and there was no inventory of documents. That may be true, true. But that's not the only reason a jury can find that these documents were not produced. And you assume these are governmental officials, they're professional, they know how to run an office, that there might be another reason they didn't produce these records besides, managerial or office incompetence. That's really an issue for the jury.
Yeah.
And
Counsel, may I ask you a question?
Yeah.
You would agree that it's undisputed, as Mr. Bonner said, that there was a lot of evidence that the Economic Development Committee existed, correct? There's evidence, there was a lot of evidence.
Correct.
All right. But would you also concede that there was also evidence or testimony or statements that people said that it didn't exist? You agree with that?
Sure. Those statements were made by some of the defendants, though, who
Yeah,
knew
but they're witnesses. They're witnesses. Prosecutors, don't forget they're defendants in this case now, but at that point, they're witnesses. They're people who are investigating. My point is that I'm not asking you to concede that it's true, but there was evidence that other people said it didn't exist, correct?
Correct.
All right, so when we weigh concealment for purposes of grand jury, we look for probable cause. So let's assume that that was concealed. Don't we have to look at materiality, and that is whether or not if you remove all of those things, if you add I guess almost this will be an add-on, right, rather than a takeaway. So I guess if you put all of those things in, would it still be probable cause to go forward with the half that said it didn't exist? You see what I'm saying? Very seldom does a prosecutor put all defense evidence to the grand jury. I mean, almost never. So the question, though, is did they hide something or conceal something that would be material, which means that with it or without the concealment or the fraud, there wouldn't be probable cause. So my question to you is, would it still be probable cause to go forward based on the half that said it didn't exist? That's my question.
No, for a couple of reasons. Number one, as soon as Montagne saw the documents and saw what was in those boxes, she immediately realizes there's no case here. The people who told the prosecutor that the EDC didn't exist were the people who knew that the Economic Development Committee did exist. That those were the people who controlled the town's finances. They had all the town's records, and they're in their offices. They knew there was such a committee, and when they told Montagne that the committee didn't exist, the jury is allowed to find that they were intentionally concealing the truth. And if that's the case, then why can't a jury find that there was no probable cause?
Because the problem is probable cause at this stage. That stage is a legal determination by the court. Even if a prosecutor gets cold feet or for other reason, I'm not prosecuting this case, that's not the end of the legal inquiry as to whether or not it's material as to does probable cause still exist.
Well, I don't know if I would agree with that. A jury can decide that it wasn't simply that Montagne had cold feet. It was more like, my God, you didn't tell me what I need to know. There's clear evidence that the committee exists, and you have the evidence in your office, and you didn't tell me. And what's going on here? And it's not as if there was a stray witness who said, "Oh, I don't know if the EDC really exists." These were LGC people. They knew all about the town. They controlled the finances. What's going on here? These are classic issues of intent. Probable cause, I get it. There's a legal component to that, but ultimately, a jury can decide whether there was probable cause to cause somebody's arrest.
But did you appeal it? I don't see in your brief you even argued that the prosecutors lacked probable cause to indict this plaintiff.
Well, it was the foreseeable result of the defendant's concealment of these records. They knew that if they
That's my question is, did you appeal it?
Well, close to that, which is that the LGC people are being sued because they knew that their misrepresentation.
You can't do it close to it. You have to appeal it. If the district court finds there's no probable cause, then or that probable cause exists, you can't just come up here and start. I mean, it's an interesting argument, and I'd like to be a little bit more focused than when we're dealing with legal issues here. There's a lot of stuff you could argue here. You could go on and on, but there's some central issues here, and I want to just tell you, if you don't deal directly with the issues, you may think you're advancing something, but what you're advancing is some nice things to say, but it's not going to resolve the case. And there's some very pointed issues in this case here, and among them exist Well, first of all, you would start out and say, we got a 1983 case, and this is where it arises under these particular points. And then you would address the district court's holding, particularly with absolute immunity. You've got Brady claims, you got all kinds of things here. There's a lot here that has to be parsed through, but when you get through it, you're only dealing with the law. I mean, all this, the probable cause thing is an interesting argument, but you didn't even appeal it. It's not before us.
This is a concealment case. They concealed evidence to the DA knowing that it was going to result in Mayor Oates' arrest. And
the motive that you give is what?
I think Mr. Bonner can address the motive better than I can.
In other words, why did they do this? I mean, what was it here that there's an intent to do this sort of thing?
She was speaking out about missing funds from the government that went to the town of Princeville. And once she speaks out, the LGC moves in and takes over the town's finances and then sets her up for an arrest through the concealment. So this is a conspiracy case withholding records that foreseeably results in her arrest when they knew there wasn't enough evidence to arrest. And you can have evidence of a tacit understanding. You don't need direct evidence of motive to conspire against the plaintiff, but that's the theory of this case. A conspiracy to withhold records that foreseeably results in the plaintiff's arrest and processing her in criminal court. Thank you.
Thank you. Mr. Rabinovitz.
Thank you, Your Honors, and good morning. May it please the court, I'm Brian Rabinovitz, Special Deputy Attorney General with the North Carolina Department of Justice. I'm arguing today on behalf of the defendants' appellees. And before I jump into my argument, I just wanted to clarify, Judge Wynn had asked about who are the remaining defendants in this case specifically. That would be Wood, Chapman, who was the SBI agent, and then the three individuals who were staff to the local government commission. That's Holloman, Hammond, and Edmondson. And Mr. Bonner had referred to Defendant Long, and I just wanted to clarify that Mr. Long was dismissed out of the case, and the plaintiffs have not appealed his dismissal out of the case. So it's only the five
now,
defendants.
having done that, tell us the issues that are in the case, and are these all 1983 issues?
Your Honor, those are the only issues that the plaintiffs have raised in the case. It is Section 1983.
I want to make sure I understand. Is it only 1983 issues?
Those are the only remaining issues in the case. Yes, Your Honor.
And what do you understand to be the basis upon which they make a 1983 claim here? In other words, what are you going to be arguing against? Because if you're going to go, whether it's Brady or whatever, I need to know what you're going to be arguing about, because we're all over the place on that. And you need to be more pointed when you are trying to assert an action under 1983. You need to be very pointed in terms of where does it come from and what is the violation here. Because the trial judge made some specific findings here, or a specific holding. Absolute immunity is one of them. So go ahead and let me hear that answer.
Yes, Your Honor.
What is the authority you're going to be arguing that they allege, that you think they allege?
Yes, Your Honor, and I absolutely agree that some of the allegations have been all over the place here. I think you keyed in on the two issues. So absolute immunity, of course, is a central issue in this case. And then the stringent burden for proving a civil conspiracy under Section 1983 is the other issue in this case.
Counsel, what is the statutory authority for the 1983 claim that you're going to be arguing on? I got all of the general title, but 1983 is not an action by itself. It comes from somewhere.
Yes, Your Honor.
A violation of some act. What are those? What is it? I mean, you just can't say Fourth Amendment. It has to be something within the Fourth Amendment, and you just can't say Brady. I mean, you got to give us something here. So what is it that you are going to? And I'm not putting it on you, but you're going to be arguing. So I want to know what you're going to be arguing. That's what I'm saying.
Absolutely, Your Honor. As best I understand the claim, and I believe that Judge Harris's questions were right on point. The seizure is basically when Ms. Oates had to go and appear in court, do a first appearance in court. her fingerprints were taken, a bond was set, and she paid her bond. That, from what I understand, is the seizure. I also agree with what you suggested, Judge Wynn. I do not see a fabrication. I don't see any evidence or any allegations really of fabrication of evidence here. I think that what we're talking about, I think their claim really is a concealment of evidence.
Oh, they have a fabrication, but the fabrication is from evidence that arises from the grand jury, which is why the judge in this case said it was absolute immunity. The question goes to the concealment because the allegations also say that it points to the 2012. That's not grand jury. So that's where you get into the concealment from my view on it.
Yes, Your Honor, that's absolutely right. Their fabrication claim is...
Judge Harris has a question. I didn't really ask the question, but...
Yeah, so. And I'm sorry, because I do feel like we need to ask your colleagues more about this too. You're not the one who brought the claims, but I really am struggling for someone in this case to tell me what is the cause of action? What's the claim? It looks like a malicious prosecution claim under the Fourth Amendment, but the district court said it can't be a malicious prosecution claim. I'm not sure that was right, but it hasn't been appealed. So what are we even talking about? What is the claim? What are the elements that you're going to argue are not here? Assuming we're under the Fourth Amendment, and you said in your brief it might also be a due process claim, but I don't see how that can possibly be true after the Supreme Court's decision in Manuel, which said, no, until trial, it's the Fourth Amendment or nothing. And they specifically said that includes claims that a grand jury indictment was tainted by falsity. So let's assume it's the Fourth Amendment. What's the cause of action? Like, it's the Fourth Amendment and what?
Your Honor, I have to confess that I may be as puzzled as you. I've lived with this case for a long time, and I find it difficult to put my finger on what the specific claim is. They've said repeatedly, and really the only constitutional claim they put forward is this Fourth Amendment claim based on what they say is concealment and fabrication of evidence. And what I would say in response is, I believe on both of those issues, concealment and fabrication of evidence, those are only claims against defendant Chapman. And I think that the Rayburg case rules the day here, as the district court recognized, because I think that those claims are both tied to the grand jury testimony. As Judge Wynn said, I think that's absolutely clear with respect to the fabrication claim. I believe that it's also clear with respect to the concealment claim. And the reason is that the court in Rayburg set out what the scope of that absolute immunity is, right? And it is not just strictly what a grand jury witness says in front of the grand jury. It also goes to claims of conspiracy, which there obviously is here, and also to preparatory activity that occurs, especially between the grand jury witness and the prosecution. And so I would argue, first of all, that to the extent they have made a claim there, the absolute immunity from Rayburg, the scope of that is broad enough to cover all of the allegations that they've made with respect to defendant Chapman. And the problem becomes for them, aside from their difficulties of articulating a clear claim in this case, the difficulty becomes that is then dispositive on the conspiracy claim as well, because in order to have a Section 1983 conspiracy claim, that's not a freestanding claim. The law is clear on that. You have to have some underlying deprivation of a constitutional right. And so if the claim against Chapman, the two claims against Chapman fall because Rayburg governs those claims, as we argue that it does, then the conspiracy claim against all of the defendants here also falls.
Yes, can I ask?
Mr. Bonner said that he raised also a 14th Amendment claim. I think that's what he said.
Your Honor, my reading is that they have relied on the Fourth Amendment throughout. Mr. Bonner, the record is large here, and there have been lots of brief filed at different points in this claim. Perhaps I'm not going to doubt Mr. Bonner if he has somewhere in his argument where he has pointed to that, but I'm not acquainted with that, but I don't know that that would affect the grand jury immunity.
I want to clarify because you can't come back up. Maybe I misheard Mr. Bonner, but I think he said 14. But your answer is, as far as you know, none exists.
That's correct, Your Honor.
But you did say that basically this is about getting together, he alleges, to undermine her constitutional rights. That's one of the first things he said, the right terms protection, equal protection under the law, and they got together and undermined her because she raised questions about other matters of FEMA. And then lo and behold, in terms of temporal timing, this comes up. That's seems to be the theory of it. He's alleging they got together and said, wait a minute, we're going to do this for liberty rights. For liberty rights in terms to be free from being arrested, free from being, as he said, subject to many years of imprisonment based on their concealment. That's what he said, I believe, that his theory is. You're saying that that's not in the case, or if it is in the case, it has no merit. Which are either both?
I believe, if I understand correctly, and I'm sorry, you're a little quiet, Judge Gregory, so it's a little bit harder to hear you. But you know, my understanding is that against all the defendants, yes, they've stated this conspiracy claim. So their claim is that all these defendants have conspired together to deprive Ms. Everett Oates of her constitutional rights. And they have mentioned, at least here today at argument, you know, several rights that they believe were deprived from her. I do not think that they've articulated an argument, and I don't see that in their brief, based on anything other than this Fourth Amendment seizure claim. And if Your Honor reads the order from the district court, what the district court allowed them to proceed on specifically was against Chapman, the concealment and seizure, fabrication and seizure. That's the way that those claims were characterized. So those are the only legal claims that they have remaining in this case, aside from this conspiracy claim. And the conspiracy claim specifically that they articulate is that all these defendants conspired to make or to cause defendant Chapman to fabricate evidence before the grand jury, or to conceal evidence from the grand jury. Those are my understanding of the technical claims that they have in this case. And Your Honor, I think as I've argued, and we argue in our brief.
Perhaps you say it too narrowly. You're saying that it's only for the grand jury's purpose, but I think they're arguing that they're alleging they came together and conspired to undermine her liberty. Now, yes, one of the mechanisms as a Chapman, they would say, is through the grand jury. But I think they're alleging that it's broader than that. And they're saying this was sort of, as I understand it, they're alleging that this was kind of hatched, this idea was hatched, that is, we're going to do this to undermine her liberty rights. And so, but all of this can't be funneled just to a grand jury, if that's the theory. You know, the theory is that, well, grand jury or whatever, to smear her in any way we can use it. Otherwise, a conspiracy can be broader than that, being an act in furtherance. Every act in furtherance doesn't narrow a conspiracy necessarily. You're saying that everything has to go through the tunnel of the grand jury. For Fourth Amendment, yes, but not for a broader concept, as it seemed to be arguing. They got together and hatched this plan to undermine her liberty, her freedom. I think Mr. Bonner said it. He said that she has a right to free exercise, a right and enjoyment of peace and liberty and pursuit of happiness like any other American. That's how he framed it. And so I guess the question, and so you're saying that that doesn't exist, or if it does exist in the case, it has no merit. That's all I'm asking you.
Yes, Your Honor. I'm saying my understanding of the claims that they put forward, if Your Honor reads the district court's order that limited the 3 claims that they were allowed to go forward on, and then their amended complaint, which is styled the first amended complaint, although it's actually, they had amended the complaint once before, so functionally it's the second amended complaint, but they styled as the first amended complaint. Your Honor, I believe that what they are alleging there is that the conspiracy was to cause defendant Chapman to fabricate and conceal evidence. And so I think that those are the technical issues in the case. However, even if this court were to give a broader reading to their conspiracy claim, I think first of all, they still need to allege what the underlying constitutional deprivation is. And I think they have a problem if absolute immunity applies to both the fabrication and the concealment claims. And second of all,
I'm sorry, I'm sorry, because I wanted to ask you about that the first time you said it. I just want to stop you there. So your position, because it's like just a bit of a brain twister for me, your position is that if Chapman is absolutely immune as to the concealment and fabrication charges, then that means that so are all the alleged co-conspirators, basically. Because it's not, if she's immune, we're not saying there wasn't a constitutional violation. We're saying sort of there's nothing actionable. There's no actionable constitutional violation. Maybe she lied to the grand jury, maybe she didn't. We can't even get into that. But you think that that kind of a holding, rather than the district court's alternative holding, there's no evidence of concealment or fabrication, but the immunity holding itself would be enough to take care of the conspiracy charge as well. There's no such thing as conspiring to do something for which Chapman was immune, is your position?
Yes, Your Honor, that is our position. And I also think, again, because of the way that I technically understand their claims, I think that has to be the case, because I think the conspiracy claim is not just that there was some freestanding conspiracy.
I understand. It was a conspiracy. I agree. The district court said, here's what you can go forward on. Your claim that you conspired to make Chapman lie to the grand jury. That's your claim. And you think if Chapman's immune, so is everyone else, effectively.
I think
if Chapman's immune, that's not an illegal conspiracy.
Yes, because I think I think there has to, if the conspiracy claim is that they conspired to cause her to conceal or fabricate evidence, and they cannot move forward on a claim that Chapman concealed or fabricated evidence, yes, it's our position that then the conspiracy falls with it. However, I would like to briefly, if I may, address in the last few minutes that I have some of the facts of this case, which I think are salient because it is a fact-intensive case. And I think the most important thing that you, Judge Harris, pointed out earlier is the issue of whether this entire SBI file was given over to the prosecutor in this case, because it is undisputed in the evidence that entire file was given over to the prosecutor. Montaigne testifies to that.
So that goes to the claim of concealment, correct?
Yes, Your Honor, that goes to the claim of
your statement is simply it wasn't concealed, it was given over.
Exactly, that all of the information that was in there was given over, and that's in the record at 3737 specifically, and then it's also discussed farther 3738 to 3744. Those are from Montaigne.
Is the concealment claim, see, we've been going around in circles, is that a Brady claim being made here?
Your Honor, they have not articulated a Brady claim or styled it.
Is bad faith an element of the concealment claim?
I think the way that they have construed it, it would either be intentionally or with reckless disregard, I think is the state of mind. I don't think that there's a specific bad faith state of mind, but intentionally, I guess, could be bad faith, maliciously, or reckless disregard. If I may, Your Honor, I think
unless it's a Brady claim, then if a Brady claim, it likely would have a bad faith. You're saying if it arises in some other vehicle. Concealment, Brady in of itself deals with the failure to disclose. So it needs to be concealed, which takes it a little further. than maybe beyond Brady, but I'm trying to understand at least if that is a violation, if they intentionally, to conceal is one thing, but to do it, conceal it with a purpose of doing it. Concealing alone doesn't mean anything if all you did is conceal. If it didn't hurt you, if there was no purpose to it. But the allegation here is a purpose here. I don't quite understand yet why it is that they would, it's being alleged why it was being done, other than maybe they just didn't like them. I don't know what it is. I mean, why would you conceal evidence in a case like this? And not that you, I don't understand that. That's the whole concealment aspect of it, the bad faith aspect of it, at least from the Brady, or at least the intentional and the recklessness of it. Recklessness of it, I will say, you know, this, what is this group called? LGD or whatever it is, that it goes down, it takes over Princeville's finances. And then they fight to keep the defendants from going in and seeing what's the basis of it. Finally, you get in, and I understand there's about 38,000 records all over the place in disarray, not filed. No one knows anything. And I'm wondering, well, who's going to take over this entity? Because it looks like to me the entity itself needed someone to take it over. It's in disarray. No one knows what. And in the midst of that file, what the facts, if you want to talk facts, what makes it really egregious, it sounds like something is wrong. In the midst of those files, you've been saying this former mayor is dealing with an economic development group that doesn't exist, and here it is, some evidence of it right here in those files. Then you say she didn't have receipts. Right in the midst of evidence, you find some of the receipts, a lot of receipts there, which frustrates the prosecutor. I don't know whose burden it is, but you got this agent who's supposed to be doing this job of finding this out, and you bring an allegation against a public official, she loses everything, including the election, the whole bit. And at the end of it, you says, well, we're going to dismiss the charges, and that's the end of it. Well, it's the end of it for the government, but not for her. She's been destroyed with all of these allegations, when all it took was to go look at what they actually had. What amazes me is they fought to keep them from doing that. And finally, the judge says, no, you got to let them do it. I don't understand that. There's something wrong in that process there. That doesn't make sense to me.
Your Honor, if I see that I'm over time, but if I may just address some of those facts quickly, I would appreciate the opportunity to do that. I think, first of all, the records were in disarray from the start. And that's what the independent audit that the town received showed. And so I'm not talking here about the state auditor's office. I'm not talking about Beth Wood and her office. I'm talking prior to that, there was an auditing agency. Every municipality in North Carolina has to have an independent annual audit. And so there was a company, Petway and Mills, that did the audit for the town. And what that audit found was that the records were in total disarray. And so
the records from the town were in disarray. So when it was taken over, you're saying it's the same disarray and going on. But if you're going to make allegations of it, it sounds like someone has to go through those disarrayed records before you levy a complaint and indictment against someone. If you got a pile over here of records, it's one thing to say, well, it's in disarray. It's another thing says you don't have any receipts. And you got a pile of stuff here. And you haven't even looked in that pile. You just make an indictment.
Your Honor, I think it's important to understand the different functions of the different agencies that were involved here. The local government commission took over the records because of the dire.
I don't want to, I'm not saying you can answer these questions. I'm just saying when you look at the totality of the situation here and the functions, I know the functions of this agency, and I know the problems with Princeville in terms of finances. But I'm saying to be able to indict someone and says, you have an agency doesn't exist and you didn't give receipts. We're not even going to look in that pile of stuff over there where the answer is, we're just going to indict. Now, whether they properly advanced this or not, there's definitely something wrong with that. Isn't it?
Your Honor, I believe that the local government commission and the defendants there were focused on the financial circumstances in the town. They did not request that the mayor be prosecuted or that an indictment.
Yeah, they started out on something totally different. It was totally different. The mayor's actually the one who went first about something totally different on it, and then it morphed into this. It boomeranged back on the mayor. Now, I understand there's some infighting, and I can understand how that happened, but I'm only pointing out, I'm not saying it because we've gotten away from the legal issues here. The legal issues here really inform this outcome. But when you look at it, you brought up the facts. I'm saying these are some bad facts all around on both sides. But I will leave it at there and give it back to my good colleague, the chief here, to determine where we go from here.
Okay, and thank you all very much. We would ask that you uphold the district court's decision. Thank you.
Thank you, Mr. Bonner.
Yes. I'd like to continue on with Judge Wynn's very astute and appropriate analysis about the large volume of documents. But I want to back up just briefly about what is the claim here. This is a 1983 claim, which basically anyone acting under color of law who deprives America of a constitutional right must pay damages. The constitutional right.
That's the answer right there. That's right. What is that? Under color of law. That's what we're trying to figure out. What is that law?
Okay, the color of law, first we have the State Bureau of Investigation, Chapman, and we have the LGC, who have the authority.
Mr. Bonner, you don't have much time. Please focus on the constitutional deprivation. The Constitution.
Yes. The constitutional deprivation of twofold. One, the seizure, taking her liberty away under the 14th Amendment. Under the 4th Amendment first, seizing her, requiring her to have to pay money, her property. And secondly, the liberty interest under the 14th Amendment. And we cited the case in, yes.
Counsel, can I stop you there? Because for a long time, it was very unclear in the law whether in a case like this involving criminal proceedings, you could bring a due process generalized liberty claim about what happens in the pretrial phase of the criminal proceedings. But then the Supreme Court very recently decided this case Manuel, and they said, we're going to clear this all up. Until the day you go to trial, it's all about the 4th Amendment. When your trial starts, the 14th Amendment kicks in. But anything that happens in the course of a criminal proceeding pre-trial, you've got one claim, and it's a 4th Amendment claim. So I don't understand how there can be a 14th Amendment claim in this case. And I will say, relatedly, I didn't see the district court let you go forward on a 14th Amendment claim. The district court initially grants all the motions to dismiss, says there's nothing here, come back with an amended complaint, but don't include malicious prosecution. And so you guys came back with your complaint, which looks like it's a 4th Amendment claim.
Well, that is correct. But the 14th Amendment has a liberty interest separate and apart from the due process interest. And of course, we did assert in the criminal case that there was a Brady violation, but it was beyond Brady. It was not just we didn't disclose, but this was willful intentional concealment. Now, getting back to Judge Wynn's factual issue about the big, large boxes of documents, here, the 2 files that we needed were not with that 35,000 to 50,000 pages. They were within arm's reach in the LGC's office, in Defendant Edmondson's office. She indeed used those files to craft with Chapman the factual expenditures for the indictment. So these files were volunteered by Edmondson in the 3rd day of this inspection ordered by Judge Smith. Why? Because she knew those were the 2 files that we wanted. She had faxed receipts from those files back in September of 2012. So we knew that she had the files, and we knew she had the Economic Development Committee file. And she knew that if she had not given us those 2 files that were in her office, where she and Chapman and Hammond and Holloman, where they all met over 20 times, that we would go back to Judge Smith and have her held in contempt. So she said, oh yeah, here's some other files in my office. And those were the 2 files. Montagnier picked up the file that said Economic Development Committee and said, oh, there goes my case. You all told me there was no Economic Development Committee. And then Hawken, the other DA, picked up the file with all the receipts, on the reverse side of which was the business purpose. This was an innocent person in the beginning. They knew she was innocent. There was more than failure to disclose. This was active intentional concealment that took away her rights, her constitutional rights that everybody is entitled to. And this case should be reversed and let these issues of motive go to trial. We don't have to explain why they wanted to shut her up about this $26 million that to date has not been disclosed. We don't have to prove a motive, but a jury, a reasonable jury can conclude that it was because they did not want to deal with her constantly complaining about the much. Your Honor, we ask you to really do what Judge Smith did here, which showed that this was palpable injustice to Mayor Oates, and he ordered us to go to that office and look for those records, and that's why we're here today. And we hope that you also can feel the injustice to Mayor Oates and reverse this case and let a jury decide the motive. Thank you very much.
Thank you, counsel. And thank you all for your arguments. We appreciate them. I wish we could come down and greet you, but we can't under the circumstances, but know nonetheless that we thank you for your arguments and we wish you well and be safe. And
thank you.
With that, counsel, I'm going to ask the clerk to adjourn the court.
Thank you all. Thank you very much for your attention and your indulgence.
Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.